Hello, hello, hello. This is Attorney Mike Revel coming to you from Chicago. As usual, we got a nice dumping of snow here in the city today. I think most of the country got it. It's kind of pointless. I had this conversation with Food Fairy earlier. I grew up in northern Michigan. First of all, you get a hell of a lot more snow than here, like a lot more. So none of this freaks me out. This is small time compared to Traverse City. Trust me. Trust me on this. But the upside up there is you can go play in it. Down here, it's like, yeah, it's kind of pretty for 5 minutes, and then it's just in your way. Whatever. That's why I decided to come back here and hibernate and do another stream. I went and dug out material despite very, very, very little court today, but I did find nuggets. Let's get to it. It's good stuff. Oh, I also got help from Zach. That never hurts. LawNerdsUnite. All right, where are we at here? Oh, that's not where we want to start. I'm on the wrong video.
Who do we have, please?
We're going to start with this one.
We'll go to ACDC, Your Honor.
All right. Deputy Milton?
Position 8.
This is fun. This is really fun. I don't know how Judge Lal drew the short straw, but she's here on Black Friday. She's here on the Saturday of Thanksgiving, and it's nothing but knuckleheads over at ACDC here. I mean, it always is, but it's a special group tonight.
It's James.
Position 8. And what is the next case after position 8 with Deputy Milton?
Position 15, Miss Wallace.
Okay, thank you. Danielle Alanis James is accused of criminal trespass causing damage to property from November 28th of this year. Her accusation number is 25 CR 7653J. Ms. James, you've been advised of your rights, and your attorney is going to be Ms. Tucker. Any priors, Mr. Howard?
Second, 2015 suspended license.
Okay, thank you. And Mr. Brown, any objection to a signature bond and a stay away and no contact?
No, Your Honor. We would just ask that you implement additionally anger management or something of that sort,
right.
Given that this was a roommate type of altercation.
Right. Is there a Christine Tahoe on Zoom? Christine or Christine?
Christian, yes, Your Honor, I'm here.
All right, then you better unmute.
Oh, Christian's a vibe. This is so fun. This is so fun.
And start your video.
Yes.
Do you want to say anything in this case?
If nothing could happen.
Raise your right hand.
Oh, sorry.
Do you solemnly swear the testimony you provide will be the truth to the best of your knowledge?
Yes.
If nothing can what?
So if I wouldn't want anything to happen to her, like anything that goes on her record or anything like that.
Mr. Tahoe?
Yes.
Can you see her?
Yes.
Can you see her in a jail?
Yes.
Can you see her in a jail suit?
Yes.
And you can't see, but she's in handcuffs.
Okay.
So everything has happened to her already.
Okay.
What else would you like to tell me?
Also, me and her, we had like an agreement about where I stay, that because currently it's in her name, but the agreement was for me to stay here for 2 years. So 1 year is left, and after that I can kind of like return the key and everything.
Who's on the lease?
She's on the list. Her name is on the
You
list.
put your hand down. And is this agreement consented to by the landlord?
Which is her, yes.
So you have a written agreement with Miss Danielle, and the agreement is agreed to by the landlord?
The apartment?
Yes.
No, we don't have that. It was a verbal agreement between me
So
and
the landlord doesn't know anything about it?
No.
So the landlord doesn't know that you're in the apartment and we're not on the lease?
No.
Okay, thank you. I wouldn't recommend you say anything else. Okay, criminal trespass causing damage to property. Ms. Tucker, does your client want to go back?
Yes, Your Honor. We have no objection to the recommendation for a signature bond, but we were objecting to the stay away order. She does also reside at that residence, and as it's been testified to, she is the only leaseholder there, and she has no desire to be displaced due to this charge.
All right. Bond is going to be set at $2,500. It says signature bond through pretrial services level 1. Miss James, you are going to report to pretrial services once a month, and you are to comply with the following conditions. No further violent contact with Christian Tahoe. You can return to the apartment, but I highly recommend you begin the dispossessory process of removing Christian Tahoe from your apartment. If your landlord finds out, you might be out of an apartment as well. Do you understand?
No, she absolutely does not understand. That's a very good idea, Judge, but she did not understand the words that are coming out of your mouth. You dropped a dispossessory in there. It ain't happening. But nice try.
No illegal drugs, no alcohol, no weapons. And I need you to complete 6 anger management classes. You will enroll and schedule and complete 6 anger management classes within 45 days of being released. If you get arrested again, if you don't show up for court, or if you don't report to pretrial, your signature bond will be revoked. Thank you. Position 15, I believe. This is
Yes, Your Honor.
Davetta Lachey Wallace, accused of simple battery family violence from November 27th of this year, case 25 CR 7662E. Ms. Wallace, you've been advised of your rights, and your attorney is Ms. Kim.
Yes, Your Honor, I apologize.
Okay.
I-
Any priors, Mr. Howard?
Second arrest, 2016, theft by receiver, carrying a weapon without a license. That was dismissed. That's it.
All right. And Mr. Brown? Yes, sir?
Actually, this is my case,
Oh,
Your
Ms.
Honor.
Gates? I'm sorry. I beg your
Yes.
pardon. Go ahead.
Yes, the state's recommendation in this case, we are okay with a $3,000 signature bond. We just ask that Ms. Wallace takes an anger management course.
What about contact?
Oh, and no contact with Marquise Wallace.
Is there a Marquise Wallace on screen? I think there is. There he is. Marquise Wallace.
I believe he may have a case as
Oh, there's Marquise, and he's also a vibe.
well, Your Honor.
Is there a case open? and
Yes,
pending?
I'm here.
You need to start your video, Mr. Wallace.
Yes.
Oh, no, he doesn't have a case.
All right. Mr. Wallace, raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
What would you like to tell us?
First, that's my wife. We're still married, and I'm still on the lease. My name's still on the lease with her. We was going through an altercation, where I had to leave the house. So I'm saying I had to leave the house for a separation. He's supposed to give her separation and stuff like this. Stuff that happens, this is not her.
Exciting and new.
She never does this. She never does anything like this. She's focused. She's job. She's on point on everything. But this particular day, she get around this one person that I kept telling her about. There's one person that drove her down. It drove her down after I left the house, because I always was there to stop people from using her.
I want to dumb her down the ticket. I want to fight that.
Are you comfortable with her living with you?
Yes.
Are you comfortable with her being back in the home?
Yes.
All right. Thank you, Mr. Wallace. A bond is going to be set at $3,000. It's going to be a signature bond through pretrial services level 1. No further violent contact with Marquise Wallace, which means that from now on, there cannot be any future verbal or physical altercations. If the police get involved, Ms. Wallace could be back in jail on a no bond or a seriously high cash bond. She will enroll and complete 4 anger awareness classes. She's not to consume any illegal drugs, no alcohol, no weapons, and no firearms. Next court date will be sent to her current address. Thank you.
Thank you.
Yes, Stephanie Milton. Great holiday. Thank you. All right, courtroom 2, who do we have next?
Position 6.
I have Tamara Horton, accused of simple battery family violence from November 28th, 2025.
You'll never believe it, but she's also angry.
Case 25 CR 7651H. Ms. Horton, you've been advised of your rights. Your attorney is going to be Ms. Tucker. And any priors?
7. Last arrest was 2004 theft by receiving. That's it.
Thank you. Is there a Jana Horton on Zoom?
Yes.
All right. How old are you?
20.
All right. If you'd like to contribute, please start your video. Mr. Brown, what's your recommendation?
Judge, this appears to have been an altercation between the defendant and her daughter. And it appears that she tried to pull her, well, she did pull her down by her hair to the ground based upon the facts given to us. We would ask, Your Honor, I would presume this is her home. I would defer to the court, but if it is, then we're asking just that she have no further violent contact, complete anger management courses, no alcohol or drugs without a prescription, and it would just be a $1,500 surety bond, Your Honor. No, nothing further.
Ms. Horton, Jana Horton, would you like to contribute to this proceeding?
No.
No? Okay. Ms. Tucker, anything else to add?
No, I just want to show up in this goofy hat, make a jerk out of myself.
Yes, Your Honor. Miss Horton is 47 years of age. She's maintained the same address for over 5 years, which is the incident location. So we are asking that there be no stay away, as well as no further violent contact with her daughter. And we are requesting a signature bond in this matter. She hasn't had an arrest in over 20 years. Of course, no recent failure to appears. So that is our request.
The bond is going to be set at $2,000. It's going to be a signature bond through pretrial level 2. There shall be no violent contact with Jana Horton, which means that Miss Tamara Horton can return to the home. But if she lives with Jana Horton, she cannot have any future physical or verbal altercations that will cause the police to be involved. She will report to pretrial twice a month. Within 30 days, she will enroll in a domestic violence intervention program and complete all 24 classes at her expense without missing or skipping them. No illegal drugs, no alcoholic beverages, and no weapons.
All right, you're going to see in a minute here. She does not like this anger management class idea at all. She does not like it. And Judge Lal does not like her response to it. It's pretty fun.
Mrs. Horton, if you have something to say, please remember that anything you say can and will be used against you in the treatment of your case.
Okay. I don't think that I need 24 weeks of anger management. The reason for this altercation is because my daughter is being very disrespectful in my house, and I asked my daughter to leave. I did not put my hands on my daughter. My daughter pushed me, and therefore I restrained her and pulled her down to the ground. I did not hit my daughter.
Miss Horton, if you are looking at the Zoom screen, your daughter is in the comfort of her home, and you are in jail with handcuffs on you. There is probable cause that you were the initial aggressor, and that's why you've been charged with a crime. Now, if the prosecutor takes this case to trial before a judge or a jury and proves this charge against you beyond a reasonable doubt, you can be convicted and face a penalty of up to a year in prison and or up to $1,000 fine. As it is right now, I can only accept the warrant which establishes probable cause that you were the initial aggressor. And given your scant criminal history record, you are still the accused in this present case. So I really don't care what you think you need. I'm going to grant you a signature bond, but I want you to complete the 24 weeks of classes. And if you believe that you don't have to, please let me know, and I'll be glad to amend your bond to a surety bond.
I believe my daughter needs to attend those same classes.
Ms. Horton, I will recommend that you remain silent.
Yeah.
Judge Law has already ruled in the matter, and your daughter doesn't have charges as at the moment.
I can also rule that you stay away from the home. Do you want me to go that far? Understand that if I allow you to go back into the home and live with Jana Horton, that you're required to have no future physical or verbal altercations. Now, if you go back home and you start pointing a finger at her and saying this is all your fault and I'm innocent and you're not, you need to let me know now, because otherwise you have no business being under the same roof with her.
Your Honor, I have confirmed that Ms. Janiyah Horton has relocated and she no longer lives at the address. I actually did speak with her prior to court and she did confirm.
Okay.
She is on the Zoom if you want to confirm.
All right. But if you get a moment, speak to your client. She needs to understand what probable cause means.
Yes, Your Honor.
Thank you. Next case, please.
We have position 10.
Okay, that's fine.
Alberto Cara, followed by Andrew DeMars. Good morning. We're here
Oh, did I enjoy that? Did I enjoy that? Absolutely calm whooping that she just delivered right there. It was so fun.
today for a bail hearing. The Public Defender's Office has already been previously appointed to represent you. I am in receipt of the Nevada pretrial risk assessment, which indicates that you scored as an 8 or a moderate risk utilizing that tool. State, are we ready to proceed with the bail hearing?
Yes, thank you, Your Honor. I believe we continued this from yesterday for the state to attempt to make victim contact. We've not been able to do that, but the state is ready to proceed today. I would note that it appears that the defendant called her on the 27th. He wasn't able to speak with her, but it sounds like he did leave a voicemail for her. So the state's requesting bail in the amount of $75,000, bondable only.
I'm going to warn you here.
Behavior in this case is disgusting. DAS with testing for controlled substances, no contact with the victim as a condition and pursuant to statute, and no firearms or weapons. So first of all, the facts of this case are pretty egregious. He went to her home, she let him in. He was upset that she had been out with some friends. He opened up a knife, took her to the bedroom, opened up a knife, told her to start talking. They then engaged in looks like a physical altercation. He began punching her in the head and the face several times. He said to her, dogs listen when you hit them in the head, so maybe you will listen when I hit you in the head. And then he also choked her from the front for 10 to 15 seconds and did a rear naked choke for another 10 to 15 seconds. She attempted to open the front door and scream for help. He stopped her and took her back into the room and punched her several more times. So his criminal history, he's got 6 prior felony convictions. Most recently, 2021, he's got a felony conviction for eluding, a separate felony conviction in another case in 2021 for felon in possession of a firearm, gross misdemeanor conviction in 2021 for attempted battery causing substantial bodily harm. It looks like in that case he and his brothers beat up an ex-girlfriend's current boyfriend. They broke a bunch of bones in his face. This was in front of his 3 children. He also failed to appear after release on that case. He was sentenced, all of his sentences were consecutive in 2021, 19 to 48, 19 to 60, 364 days. The Nevada Department of Corrections website showed a parole eligibility date of February of this year and an expiration date of April of this year, so it appears he was in prison at least through this year. 2015, he's got a misdemeanor conviction for domestic battery. That was reduced from a domestic battery with substantial bodily harm. That was out of this court. 2014, felony conviction for unlawful use of ID of another. His probation was revoked in that case. 2013, a felony conviction for assault with a deadly weapon. 2007, a felony conviction for burglary and a separate felony conviction for assault with a deadly weapon. So he has a very violent history. It looks like he was just recently released from prison this year. This case involves a significant level of violence. So the state's requesting $75,000 bail bondable only, DAS with testing for controlled substances, no contact with the victim as a condition and pursuant to statute, and no firearms or weapons.
Thank you, defense.
Thank you, Brad. We're asking for a $5,000 bondable amount, and we're asking that because we were able to contact a place to stay for him who could confirm that he not only had a phone, but he also had a job as a diesel technician. Because of those contacts, we're able to lower his NPRA score from an 8 to a 4, putting him closer to that low-risk range. And since the NPRA is our tool to predict whether or not he'll have a problem while he's out on bail, we're asking for that smaller amount in terms of bail.
If that record ends on low risk, then that tool is useless. That's all I'm saying.
$5,000 bondable, Judge. Thank you.
Thank you. Given the information provided, the court does find that the Nevada pretrial risk assessment would be reduced. However, given the information, it would be reduced to a 5. Based on the facts as presented, the Nevada pretrial risk assessment and the factors as outlined in NRS 178.4853 and NRS 178.498, the court does find that the state has met its burden by proving by clear and convincing evidence that bail is necessary in this case in order to ensure the safety of the named victim in this case and the safety of the community. I will note just for the record the prior history of violence involving women, the history of noncompliance, the recent release from prison, as well as the significant threat to the named victim as outlined in the probable cause declaration. With that in mind, bail will be set in the amount of $50,000 bondable with no 10% cash option. If the defendant is able to post that bail amount, sir, you will be required to be supervised by the Department of Alternative Sentencing, where you must check in with the DAS within 24 hours of release. I am imposing the condition, and that begins immediately, that you are to have no contact with the named victim in this case. State, just to confirm, the court has that it is Elizabeth Gutierrez, and that's Elizabeth, Gutierrez, Gutierrez, with the residence at. So, sir, you are to have no contact and must stay 100 feet away from the victim and that location. Cannot contact or attempt to contact the victim in any way, including in person, phone, text, email, electronic means, or through social media, either directly or through an agent. That means someone working on your behalf. That will be pursuant to this judicial release order, as well as pursuant to NRS 178.4845 for a period of 120 days. And state, just to confirm, is that the correct information that you have for the named victim?
That is correct, Your Honor. Thank you.
Thank you. Sir, if you violate this order, you could be charged with a misdemeanor found in contempt, have your release revoked and be remanded into custody, have any of these conditions modified, and or any other legal punishment. I am requiring that you cannot possess any firearms or weapons, as the court does find that that is necessary in order to ensure the safety of the community and there's a sufficient nexus. And the court will not be imposing any testing requirements at this time. The court does not have sufficient information to find that that is necessary, appropriate, and a least restrictive means. That will be the order of the court, and we will go ahead and set a 72-hour hearing, which will be set for December 5th at 9:30 a.m. Thank you.
Your Honor, he was arrested for PCS.
Thank you.
Judge, was that?
Thank you. I think this judge was good overall, but that was kind of snotty. I mean, she said there's no basis to do like drug testing for him, and the prosecutor said, well, he was arrested for possession of a controlled substance, and her response is thank you.
50 for 50,000.
That is correct.
Thank you.
And Judge, the last thing I would note too is that unless I missed it, he scored an 8 on the NPRA. We did find his job. That's 1 point. Phone is 2 points. And then his residence would be 4 points. So just out of an abundance of caution, just for clarifying the record, I understand the court's order.
Thank you. So just for the record, the information that you had provided was that it was a future residence, not a current residence. That would not comply with any of the requirements as set forth in NPRA. Thank you.
Courtroom 2, who do we have, please?
I'm wearing the robe here, people. All right, I've got a crazy one from Zach. Let's do it.
Looks like we have everybody connected, so we'll get started with the hearing. I guess what I'd like is for counsel and whoever's going to argue the motions today. So whoever those counsel are, if you could put your appearances on, starting with the Ward Brothers party.
Yeah, good morning to you and your staff, Your Honor. Brian Katchner on behalf of counter defendants, Ward Brothers LLC, Bernie Ward, and Sandra Ward.
Thank you.
Good morning, Your Honor.
All right.
Zachary Stewart on behalf of the plaintiff, Ward Brothers, and counter defendant, Heather Ward.
Thank you.
Your Honor, David Dobrev. I'm the attorney for Northern Michigan Elder Law. I'm representing myself pro se as a counter defendant, and I have several employees appearing here with us that are also counter defendants I represent.
Okay, so Mr. Dobrev, you're attorney of record for all parties on your side?
Yes, I misspoke. Counter defendants, counter plaintiffs, Your Honor. For Marilyn Taylor, Jennifer Bartlett, Emily Evans individually, as well as Twyla Johnson and Jill Smigilski, who unfortunately could not make the hearing tonight.
Okay. All right. Thank you. So we're on the record today. We originally had this hearing scheduled for October 16th. I appreciate counsel's patience. I had a family emergency I had to attend to that day, so the court had to move the motion hearing to today. In the interim, I believe Heather Ward also joined in the original motion through her counsel. I've had a chance to review all the briefs, the attachments that were submitted from both sides. So today is the opportunity for the court to hear oral argument. I do want to officially go on the record, though I neglected to do that. So this is, and I'm just going to go by the original caption, Ward Brothers versus Northern Michigan Elder Law, although of course there are counterclaims here as well. This is Charlevoix case number 250848-28-CH. I'm presiding over this matter by assignment from SCAO. And in terms of oral argument, this is the plaintiffs and counter defendants motion. So Mr. Katchanar or Mr. Stewart, whoever would like to proceed with arguments on behalf of your respective clients.
Yeah,
I'll let Mr. Katchanar go first. Go ahead, Mr. Katchanar.
Okay, makes sense. Thank you. Your Honor, do I have to put my appearance back on the record now that we're on?
No, we're fine. Thank you.
Okay. All right. So, Your Honor, I guess there's quite a few claims in this case with respect to the counter complaint that was filed by the counter plaintiffs. As it stands, there's 7 counter plaintiffs that have alleged 10 claims against 4 counter defendants in that complaint. There's a total of 280 claims just on the counter complaint alone. And most of those, as our briefing indicates, are legally deficient. So the purpose of this motion, the counter defendants just wanted to seek partial summary disposition to eliminate those claims that are deficient so that we can have like an efficient and orderly discovery period in this case. And given the breadth of the allegations and the amount of claims that are involved, I don't want to just regurgitate what's in our brief. I would like to more specifically focus on any questions that the court had with respect to any one of the arguments that we made. So I would invite any questions that the court has, or I can just get into the arguments.
Yeah, I don't really have any questions at this point, unless Mr. Dobrev says something that raises a question.
That was a very reasonable approach. I like what he did there.
For me, but I thought both sides were clear in their briefing. I feel like I've got a pretty good handle on what the issue is here. So
I thought that might be the case. So I'm not going to waste the court's time or anybody else's time going through each of those arguments. I guess the only thing I would like to bring up is just, the response brief and the issues raised by Mr. Dobrev, I think he argues that our motion improperly cites to documents and information outside of the pleadings. I think that's just patently false. Our briefings focus specifically on the allegations of the complaint. We never left that complaint. So I do think that the C8 portion was proper. Mr. Dobrev also raised an I2 portion motion for himself. I think that goes outside of the scope of the motion that we actually filed. We haven't filed any responsive pleadings in this case, so to bring a motion based on the pleadings seems a little bit inappropriate at this time. And then I think he also brought up the standing issue, saying that, all the counter plaintiffs do have standing. And I would just quote from the Lansing case. It just says, quote, "The standing inquiry focus on whether a litigant is a proper party to request adjudication of a particular issue." That's the Lansing case, 487 Mish at 355. And that's precisely what we're challenging here. A lot of these claims are brought by individuals that simply aren't proper parties to request adjudication. So we would just ask that the pleadings get cleaned up in this case. And, hopefully, like I said, we can proceed with an orderly discovery period so that we can get to the bottom of what the legitimate claims are.
Thank you. Mr. Stewart, anything to add on behalf of your client?
I won't add much more. I agree with Mr. Katrinar, and I think that the court put it well when you first started this earlier, that we joined in because of the delay, really, and obviously we understand that. And with respect to Heather Ward, it was in our motion itself, and I'll reiterate on the record right now that Heather Ward is not a member of Ward Brothers LLC. She's got no interest or say in the ownership of the property. That's the issue of this lawsuit. She has no say in the agreement that ties the two buildings together, the Belvedere agreement. She lived in the building for a short period of time, and the actions that are stated in the counter complaint are not enough to amount for any liability for Heather Ward. And so with that, I would just reiterate that Ms. Ward's position is on the same basis as Mr. Katrinar with his representation of the other counter defendants.
All right, thank you. Mr. Dobrev?
Thank you, Your Honor. Let me make sure I'm on. I find it interesting that Heather Ward suddenly is, not engaged and was not complicit in what's happened here, considering it took most of the delay that happened in the front end of this counter complaint was the delay in service that the current party representing Heather Ward refused service initially. She was only served shortly before we were about to hear a motion for alternative service, which was another ridiculous delay. It's pretty simple what we have here. We have a Ward family combined effort. They've engaged in a multi-year coordinated campaign to destroy my law firm, to intimidate me, to physically obstruct my deeded restricted parking covenants, my property rights. Through the limited discovery we found, I've discovered you can stand in their apartment and listen to my client and our conversation standing in our waiting room, let alone now because of the removal of the insulation, we've discovered that you can hear people going to the bathroom. And my clients and my employees have had to endure Bernie Ward coming over to our office and confronting them on their bathroom usage. What we have before us is a procedural fog issue here, Your Honor. I think that's what they've created. Just that legal principle established by the former owner in this case, like Bob Hoffman.
Yeah, things just got worse.
He set this up. Him and the former owner before the Ward brothers. There are restricted covenants that run with the land. I think it's really important to point out the two sides of the coin, that they're both the Ward Brothers LLC and the individual counter defendants, Bernie and Sandra, are seeking to put before the court here by trying to get away with kicking out counter complaints. However they multiply because of the years that have gone on in this thing. All of this to me it was a conspiracy that started with Heather and the behavior of her while she was a tenant. She's on video. That's part of the initial complaint, counter complaint. It's cited in there. They of course said it's false and untrue or misleading or whatever their answers were to it.
I think this is a farce of mismalice of justice.
They've negated that. They've been aware that she stated, "I'm tired of the war," indicating she was involved in some sort of war. I was trying to run my business after the successor to the Hoffman and Hoffman law firm, as I was his succession retirement policy. Part of that agreement was I was going to buy the building if that went through, which I did in 2022, Your Honor, with the help of my wife. And I'm the sole owner of Northern Michigan Elder Law, a professional limited liability corporation. I'm a lawyer that is employed by that corporation. I'm a W-2 employee, and I have a W-2 employee attorney, Emily Evans, sitting here, who's a counter plaintiff. I have employees that have a right to go to and from work, and frankly, their rights are intertwined, as they have a right to park in the parking spots that are afforded them at their business, and they can't go to work without being able to park there when there's, on the low end furniture.
All right, Mr. Dobrev, do individual employees have a right to bring a trespass claim?
I believe they do, Your Honor. I believe I do as the owner of the property through Northern Michigan Elder Law. They certainly have a right to bring a nuisance claim.
I'm not asking about a nuisance claim. I'm not asking about a nuisance claim. I'm asking about a trespass.
The trespass argument is valid to Northern Michigan Elder Law PLC.
What about the other?
There's no question about that.
About the other counter plaintiffs.
That's all stuff that can be worked out. Like I still think the
that's not my question. Mr. Dobrev, that's not my question. My question is, do employees who don't have an ownership or possessory interest?
No, not as to trespass, Your Honor. No, nuisance, yes.
Okay, so why would your claim for trespass include all of the individual counter plaintiffs if they can't recover?
No, it's notice pleading, Your Honor. It's that doesn't have to be like fraud and the other pleadings. It doesn't have to be pled with specificity. They just have to be put on notice that they've trespassed on property, whether that's the plaintiff is one of the several or two of the several. They still trespassed.
Okay, so if this were to go to a jury trial and the jury awarded damages on the trespass claim as to all plaintiffs, which is how it's pled, then how do we decide who gets the damages? Would we have to add an extra jury question in there as to which plaintiffs you're awarding?
I think they would decide that if by law they couldn't do it, then the jury instruction when we got to that point would be, by law the individual plaintiffs don't have a right for trespass, but they do for nuisance, so you can allow damages for that. We're not even through discovery yet. We haven't even started a scheduling order, and this thing got filed in March.
Okay, all right, thank you. Any other arguments on your behalf?
Certainly. I think if you look at and why I think my counter motion for decision on these pleadings is valid. Look at the complaint, Your Honor. This is on the complaint alone. They filed for money damages individually. Bernie Ward incurred these. Sandra Ward incurred these. They're asking me to pay for their Marina boat pump station, which is the business located behind us, and the repairs that are related to that. All of these repairs, with the exception, I think, of one invoice, predate my ownership. The concrete work's done in 2020 when they unilaterally removed a tank from outside the building that had nothing to do with the structural components of the building. Yet they're sitting here today using the Ward Brothers entity to get recovery for the damages to that. But then they're arguing that my individual plaintiffs don't have a right to bring claims against them because they're not part of my LLC. You know, what is the fraud in this case? I think the fraud is clear. They filed fraudulent receipts that have nothing to do with anything in this lawsuit or anything with Northern Michigan elder law, represented them that they did, represented to the court and that they somehow are entitled to damages. They've negated to the fact that that Northern Michigan elder law and myself have reimbursed them over $2,000 for the cost since I've owned it. Everything that is mutually related to our shared wall structure, I don't even question. I paid it. I paid a $1,711 invoice. I paid a $253 invoice. I replaced a flower pot that was actually in my parking spot that I hit. You know, I paid for everything that would have been shared. And I'm not even sure this agreement makes me pay for those. What I think is really important here is they didn't add themselves as non-parties. They didn't add Robert Hoffman, who owned the building before. They sued me. And they continually interfered with our rights to enter our property. They made it difficult for our clients, our senior clients, to enter our property. I don't think that their claims about standing are even remotely accurate. I think standing under Lansing's pretty clear that if you have a specific interest, special injury different than the public, you have a right to sue. They certainly have a nuisance claim. They certainly have an invasion of privacy claim once we learned they were listening to our bathroom usage in our conversations in the office. They certainly can join in the conspiracy claims. You know, and as to Heather Ward, she's not a bystander. She was one of the initial tortfeasors in this whole thing. It's irrelevant whether she owns something or not. If the tenant throws a brick through my window, the tenant can still be reliable. Under Adkins, the case I cite, liability for nuisance and trespass, or at least nuisance, attaches to the actor who causes the invasion, not the deed holder. It's irrelevant if she's a tenant or a visitor to their property. She's doing so under their instruction. She's a tortfeasor. If she's doing it under their instruction, she's conspiring with them. I've submitted video evidence. I think it's very clear she's indicated I'm tired of the war, and they sought advice from police officers and claimed in that video that the police officer said something different, but clearly failed to show them the actual restrictions. They ignored all of the police officers' attempts at intervention, including our prosecutors. She's not a bystander. She's an active combatant in this thing. She physically put her lawn furniture out there, but she wasn't as bad as her parents, which 2 years later were putting their outdoor refuse in my parking spot. There was dog poop and covering all of our parking signs. I'm a professional business. Having clients show up to your business like that, there's fundamentally something wrong here. You know, it seems clear to me this is 3 years that Bernie Ward, Sandra Ward, and Heather Ward, while she was there, they wanted to put me out of business because the building's more valuable to them because they own the building and the business behind them. They own the building next door to me. And they were shocked when they found out I bought
it. Mr. Dobrev, I think we're getting outside of the legal arguments here. Do you have any more legal arguments to support?
No, I'll just conclude, Your Honor. I'm hoping that this court sees through the smokescreen. None of their claims on the complaint are valid. They failed to join Bob Hoffman. If he was responsible for anything, he owned it before I did. He benefited from it. I didn't. They're seeking expenses for their marina and things that shouldn't be charged to my business. I have an exclusive right to that westerly parking covenant, just like I can't interfere with their parking covenant. I'd ask this court for a declaratory judgment. I'd ask you to dismiss their complaint with prejudice. I deny Heather Ward's motion.
In all seriousness, you do make a good point. He really should have somebody else representing him. He is in his feels, and I don't mean that in a bad way. He's mad. He thinks that these people are out to get him, and they may be or may not be. I don't know. But he cannot do this objectively. And I don't think he's stupid, but he's too emotional about it, which is why you don't represent yourself.
She's a primary actor in the nuisance. Judgment on liability. I'd like this thing just to go to the jury with damages at this point. This is an unbelievable stress that it's got me into, and I'm trying to practice law. Sure, no one has sympathy for that, but it's very difficult. I don't have anything further, Your Honor.
Yeah, no one cares. I mean, what you're saying is true, and still no one cares. That just sucks. Sorry, you're a man. No one cares. Hate it for you. But that's how it goes.
I appreciate your time, and I'm very thankful we're in front of you in court.
Okay. All right. Thank you. Mr. Katrinar, Mr. Stewart, it's your motion, so I'll give you both an opportunity to respond before I make a ruling.
Yeah, Your Honor, I think just very briefly in response, I think most of the issues touched on by Mr. Dobrev have been addressed in our brief. So I would just rely on our briefing in response to most of that. But the one thing I would say is, I think this is a good example of what the problem is here. Is number one, there's a ton of claims alleged by all parties against all defendants, and all we're looking to do is clean that up. We're not arguing on behalf of our clients, I should say, that this entire complaint needs to be dismissed. All we want to do is make sure that we have an orderly discovery period so we know which claims are being alleged by which people against which parties. And I think our briefing in this motion served to clean that up and kind of admit where they have met the pleading standards and just seek dismissal of those where they haven't. And then with respect to, again, I think part of the issue here is we've gone from a request to clean up the pleadings to him asking for summary disposition of the original complaint, which is not at issue here. So it seems like there's this scattered shot kind of going in all different directions approach to this. And again, all we're looking to do is clean this up so that we don't waste a ton of time in discovery, that we don't have to go through 10 different claims at depositions with 7 different plaintiffs, have the true claims that have been properly pled here so we can get through discovery, figure out what the facts show, and, proceed forward in that fashion without wasting a bunch of time and without, the potential for a lot of discovery issues and extended discovery periods needed to accomplish all that work. So that's what we're looking for. And again, we rely on our brief. I think all of the issues have been adequately briefed. And without any additional questions from Your Honor, we would rest on those.
Thank you, Mr. Stewart.
I'm in agreement with Mr. Katrinar. We did ask for a C8 on all counts against Heather Ward. And I guess as a response to that and sort of a modification of that, I would say that while we believe that none of these counts or claims against Heather Ward amount to a potential liability of Heather Ward, we certainly stand with the same idea that Mr. Katrinar has put forward to the court. We need to clean these pleadings up so that we can take discovery and accomplish the goals that need to be accomplished. And obviously, if Heather Ward needs to stay around a little bit longer because there are some questions of fact with respect to a potential nuisance claim or some of these other issues, then we would, we'll go forward with that and we will take discovery on that and potentially move for a motion later on. But I will stand with Mr. Katrinar in terms of the way that the pleadings, the way that the motion has been set forward, and with respect to the idea that we are trying to clean this up so that we can take discovery in an efficient and orderly manner.
Okay. All right. Thank you. So again, I did have a chance to review all the written submissions of the parties. I did review the amended counterclaim very carefully in light of motions here. So first of all, I guess I would say, number one, I'm looking at this at this stage of the procedural posture of the case, and really, and I think Mr. Stewart and Mr. Katchenar have really kind of alluded to this, maybe unintentionally with their statements here, which is we need to clean up the pleadings. And so I'm viewing this much more as a motion under 2.115 to correct pleadings or for more definite statement than I am really motion under C8. I really don't even think we're at that point yet, given the pleadings. And I think kind of the arguments of the moving parties bear out the way that I'm looking at this and after having read it. So I'm actually glad to hear them use the words like cleaning up, because that's the way I view this. I understand why it was filed as a C8 motion. I get that from a procedural standpoint, but I really think it could have been and maybe should have been filed under 2.115. Certainly, Mr. Dobrev, your argument regarding the law as the pleading is correct, and in the Lansing case says what it says, and it is notice pleading. However, notice pleading, part of notice pleading is making sure that the pleadings are sufficient to show who is suing who and for what and on what basis. And Mr. Dobrev correctly cited Lansing in that a litigant has standing whenever there's a legal cause of action or the litigant meets the requirements of a statutory cause of action. And I don't think it's good enough to just group all plaintiffs into one and say, well, that's notice pleading because the defendant knows what's being claimed. Well, they know that there's a trespass claim, but they don't know who that claim is being made against and on what basis. And so I don't think what counter plaintiff has done in their amended counterclaim meets the standard of notice pleading. And I think Mr. Dobrev's brief, kind of even acknowledges that, because right after the sentence where he cites to Lansing, he states, here each count implies which counter plaintiff asserts that claim. And I don't think it's good enough for a plaintiff to just list all plaintiffs in a claim, whether or not that claim is actually recognizable, whether or not any of those individual plaintiffs actually have legal cause of action or a statutory cause of action. And the example I would use is the one that I raised here today, which is the trespass claim, where some of the plaintiffs here who clearly don't have a possessory or ownership interest in the property they don't have a legal cause of action or a statutory cause of action for trespass. And I don't think it's good enough to just say, well, the defendants should be able to figure it out by implication. And later on in the brief on page 11, Mr. Dobrev states, David Dobrev, assuming individually Mr. Dobrev, and other employee counter plaintiffs plead limited claims. He makes that statement in the brief, but all the claims that are pled are to all plaintiffs. So to me, that's a problem. And to me, that's not sufficient to satisfy notice pleading and provide notice to the defendants who is suing who for what and on what basis. And I think the argument that, well, we just send it all to the jury, and then if there happen to be some plaintiffs who legally can't recover, we just tell the jury, well, you can't recover for those claims. Number one, it would never get that far because the opposing party would be moving for a directed verdict at the close of proof, saying there isn't any evidence on which a jury could give these certain plaintiffs any relief. But I also think it's just not a good argument to say, well, we're going to admit as for part of this motion hearing that some of these plaintiffs can't bring a motion for trespass, but we want to make the defendants defend those claims all the way through to a jury verdict. I mean, that just doesn't make any sense. So, and it's certainly not permissible under the rules of pleading or notice pleading. So I find that the defendants are correct that these pleadings need to be cleaned up, that the counter plaintiffs need to plead with specificity who is suing who for what and on what basis. And if there are plaintiffs that can't, on the face of the pleadings, meet the statutory requirements for pleading a trespass, then they can't be included in those counts. And the counter plaintiffs need to, again, plead their claims so that plaintiffs that clearly are not entitled to relief under a particular claim aren't included in that claim. So I'm granting the motion, but I'm granting it as a motion under 2.115, not a motion for summary disposition. So the court is not dismissing any of the counter plaintiff's claims at this time. The court is going to order that counter plaintiffs amend their counterclaim within 30 days to comply with the court's ruling on the record here today. And then counter defendants, to the extent that, those pleadings still do not plead a cause of action. The motion here under C8 is being, again, I'm not deciding it under C8, so it's without prejudice. Counter defendants are more than able to file another motion for C8 to the extent that the amended, which would now be the second amended counterclaim, doesn't set forth legal or statutory causes of action with regard to any particular plaintiff. With regard to the counter motion here, a lot of the arguments made by the counter plaintiffs here involve factual allegations, which I have no idea whether they're true at this point or not. Certainly would need to be supported under C10 with documentary evidence. Then the counter defendants, of course, would have the obligation to bring forward documentary evidence to counter those, at least to create a question of fact. But certainly as it sits here, just based on the pleadings, I cannot say that the original complaint, which Mr. Katrinar is correct, that's really not before the court today, a motion on the original complaint. But certainly as to that complaint and to any of the defenses to the counterclaim, certainly there is not enough before the court at this time to find that there's no question of fact that the counter plaintiffs are entitled to any kind of relief, such that the only issue that would be left is for damages, just based on the arguments here today. So for those reasons, again, the court's granting the motion pursuant to MCR 2.115. The court is denying any motion pursuant to 2.116I2 or I5. And so Mr. Katrinar, I believe you were the original moving party here, so I would just request that you prepare an order that reflects that ruling of the court today. This ruling applies equally to Heather Ward. Again, I'm not making any factual determinations today about whether or not she has liability. Mr. Stewart, some of the arguments that you made here today certainly were factual arguments as to her degree of her involvement. Mr. Dobrev made counter arguments as to factually her degree of involvement. I'm not in a position to be able to rule on that today without any kind of documentary evidence, certainly not just based on the arguments of counsel. So, but I do think Heather Ward is equally entitled to a more definite statement of the claims here. So the ruling as to 2.115 applies equally to her, joined her in the motion. And then again, the order should direct that counter plaintiffs have 30 days to file that complaint, and then we'll go forward from there. That's all I have for today. I appreciate all the arguments of counsel here on the record today, and everyone's free to disconnect. Hope everyone has a pleasant Thanksgiving.
You too, Your Honor. Thank you very much.
Well, that was fun for a while, but then it got reasonable, and then it was like being at work. It was interesting to me. I don't know what the hell they sued him for. I might have missed that. He's counterclaiming that they're doing all this stuff. What? Instead of naming all these parts, I don't know. I shouldn't say. It's another state. Okay, it sounds like an effing tortious interference of business claim on his end. And it's only his. Nobody else. Nobody cares. But he's doing stupid stuff. That's the way it seems to me. And I don't know what they're suing him for at all. And I don't know if there's any merits because I didn't get to that part. All I heard about was the counterclaims. but he's making a bunch of counterclaims on behalf of employees of his law firm. And he's a salaried employee of his law firm. I don't know. It's a real weird corporate setup too. That's not relevant to the case, but it's weird to me as a law firm owner. Very weird. Anyway, none of that matters. You giving me the hook? Yeah, I know. It's not very interesting, but I needed to process. Thank y'all for coming out. Behave yourselves. I am not bailing you out. I am not going anywhere. It's cold and it's snowing. Have a good night.